We call in Creator Energy to assist us in dealing with the fullness of every day and the speed with which they move. We ask to be guided and protected always, for there is a pressure and much requirement for things to be attended to. We can rest in knowing you have our backs, that we are able and capable of facing whatever comes. Sometimes more patience is required. Sometimes muscling through a difficult situation is what is necessary. Going with the flow without knowing the destination, result, or outcome can actually be freeing if we practice the phrase, let go and let God. Above all, let us express gratitude for the presence of one another as we stand firm in our I am. All of us here are here for a reason. So let us just say thank you, thank you, thank you.
Hello, my name's Ron Vroman. I'm recruiting for the Oregon Statewide Second Amendment well-regulated militia. This is not to replace or instead of any other militia, such as the one that Kate Brown did away with, and such as the one that people have been intimidated by as they were engaging in something they shouldn't be doing according to somebody else's rules or laws or Oregon revised statutes, which don't count because this is a Second Amendment well-regulated militia that I'm recruiting for. What other people do is their issue. Right now, we have a lot going on, and I'd like to bring you up to date just a little bit, as I would like some people outside of Oregon to take a look at this. I'm going to couch it a little bit different than normal. In 1775, before there was any sort of government, those folks decided they needed a Navy and a Marine Corps before they did anything else. Then they decided that they needed a unanimous declaration from the 13 united with a small u states of America. They were still separate 13 colonies, 13 states. Some were commonwealths. I digress. So what we have is a constitutional Republican form of government, but it is designed as a confederation and perpetual union. That's how it was designed. Nobody has taken the trouble to change it, and it takes a few people to get it together and change it. It's been changed 13 times, 10 times all at once. That's what I'm going to be talking about right now, the 10 times all at once. In those 10 times, there's number 7. In suits in common law, this is where the fraud starts. In Article 3 of the Constitution of the United States of America, as it was styled in their Confederation and Perpetual Union, and the Constitution is just the last and final alteration to the Confederation and Perpetual Union's articles. I read the paperwork for the last meeting of the Confederation under the Articles. He was the last one. He closed it down and they moved over. They moved over. They did not disband, throw away, nothing. In the Constitution, it says they bring it over with them. So the United States of America is still present in the Congress assembled in the 10-mile square known as Washington District of Columbia. That is where the constitutional government of the Confederation and Perpetual Unions states, there are 33. Oregon is the last of the several states. Nevada is something else. It's still a territory in jure. In de facto, they made it a federal state. Federal doesn't happen until Confederation goes away. Confederation went away as a governing force, sine die, March 1861. It has not been reconstituted properly since. There has been no Congress assembled since March 1861. Step one is to assemble. That takes 20 out of the 33, with South Carolina included. Then you have a quorum and you can open the Congress assembled of the United States of America, original jurisdiction, with a provenance, with justice, with remedy, and in common law and equity. Now, in Article 3, it says law and equity. Article 3 is amended by Amendment 7. Amendment 7 suits in common law. It identifies exactly what law is. Law and equity. It's common law and equity. Juries take us to equity. When the jury cannot find in law, the jury can move to equity and make a remedy. That's what we're about. We're about a constitutional Republican form of government where it's written down and it is executed properly. Not this fraud upon the people that is being perpetrated at every level all along the way. So, how do you bring about Article 1, Section 1, all power is inherent in the people? By reading the prompts. Article 1, Section 1 in Oregon's Constitution, states that all power is inherent in the people when they form a social compact. So then you look how to do that, and we did that, and you keep following the prompts, and the prompts are there and they're clear. And just recently, the Fifth Appellate and SCOTUS both agreed in Jarchese versus SEC, or SEC versus Jarchese 603 US 109 2024. They can't give you any kind of kangaroo court. You have to have your proper Amendment 7 court. SCOTUS and the Fifth agree on that. SCOTUS went so far as to say not only Amendment 7, you have to have Article 3 also. And Article 3 we have. Now, how do you establish something like that? Well, listen up, sheriffs. In 2017, we filed, before we were named, paper on every sheriff and 17 senators that had voted to violate our unalienable rights by breaking their oath and voting for gun control. So we wrote the paper up and we brought it over and we delivered 17 to the Secretary of the Senate. Ray served them. I was there as a witness. Then we drove over to the sheriff's office, the office of the Oregon Sheriff's Association, and we served their agent there for all 36 sheriffs. And basically it says you've been notified that Article 7 amended is bogus, and we know it, and you've been notified. And in addition to that, we also know that you're selling concealed carry permits, which breaks your oath. You're infringing. I don't care what the legislature does. The legislature on Oregon on January 21st, 2021, under the leadership of Tina Kotek, decided to hold session in the State House with the doors locked and we, Article 1, Section 1, locked out. Well, in the Constitution for Oregon, it says, I think it's in 14, you can't do that. You cannot hold a lawful session when we're locked out, but they did it anyhow. Then Mike Neerman opened the door. Then they hit us with sticks and squirted us in the face with, I don't know, some vile stuff that hurts the eyes. They're not there for our peace, safety, and happiness. That's a fact. So the legislature was tried and they were found guilty of breaking their oath, and that is a done deal. And not one of them, and they have all been served. I was standing in the same room and watched Drazen, Christine, I believe, I watched her get served. She knows that she has been found guilty with a verdict of breaking her oath and having no honor and unfit for a position of trust. And yet here she is running for the Republican Party for governor. She broke her oath in 2021. She's illegitimate or illegal. So what's going on right now is the de facto is being bumped up against by the jure, and every place in history that you read, you'll find that when this event comes up, the de facto folds because they cannot stand against public opinion. And the next time they have to go before the public will be standing there armed with the knowledge of you have no honor. You cannot hold a position of trust. If you can't take an oath and keep it, you're not worth the effort to put in office. If you do not have a bond and you're not bondability, if you don't have a proper oath, well, then you have to abandon the office. And whoever is running for that office, we will be assured is capable and qualified from top to bottom. We will have a constitutional Republican form of government this year, 2026. And I yield.
Hello, my name is Charlie White, Court Administrator for Oregon's Constitutional Jural Court of Record. The unexpected death of a 25-year marriage partner who was given home and all shared property to her in her name has turned the surviving successor husband's world into a full-time job and learning curve, lest he become homeless and penniless. Ordinarily, the surviving spouse would be the beneficiary of what remains from the state's probate taking their pound of flesh. In this case, the deceased created a trust and willed everything to their estranged daughter upon her death. That her demise preceded her husband, who is still living in and with all they built together, has cast him into literally fighting for the roof over his head. Our Article 3, Article 7, Amendment 7, Jural Civilian Common Law and Equity Court of Record, is a fount and litmus test for the laws of nature and of nature's God, battling on behalf of the man, in this case, against a godless, de facto, that is, illegal or illegitimate, color of law, commercial enterprise, who would even consider this situation winworthy. There is no heart, soul, or spirit in this fight on the part of the de facto, plain and simple. I'm going to read our court's document, which is a court order, which was entered into the case. This is an order granting Ron Vroman's ownership from Oregon's Constitutional Court of Record. This matter came before the court June 2026 with a sudden probate filing case number 26 PBO 2355 in the Washington County Circuit Court here on Oregon. That court is a de facto color of law entity additionally operating from a false statement and assumption. Contrarily, Ron Vroman, now a widowed successor husband since August of 2025, has been and is currently living at their shared property of over 20 years. Unexpected circumstances prompted Ron Vroman to file for quiet title on the said property, recorded on 01/07/2026, to address any clouding of ownership and occupation, and to ensure he was secure in the required claim and paperwork. Our Jural Civilian Common Law and Equity Court of Record has been involved throughout the complicated process of discerning and addressing the numerous facts and evidence of ownership. Having reviewed this abrupt development regarding probate, our Article 3, Article 7, Amendment 7 Court of Record has determined and confirms the property and all contained therein is solely owned and inhabited by surviving spouse successor Ron Vroman. The property described as Lot 10 Brookview and located at 14725 Southwest Glenbrook Road, Beaverton, Oregon 97007, is to be rendered as the property of Ronald C. Vroman, living surviving spouse successor of deceased Aida C. Vroman, who established a trust with herself as trustee. This is the decision of our court. In Article 3, Article 7, Amendment 7, Jural Civilian Common Law and Equity Court of Record in original jurisdiction with ex parte Milligan implemented. And I signed it, Charlie White, Jural Court Administrator. And we had signed also our court clerk, a deputy clerk, and our deputy marshal. And this was submitted to that case. So on his own behalf, the successor spouse has become a defender. And by having to pay $281, he has entered the case to be a defendant of what is rightfully his property. uh, one should not have to pay for defending themselves when a case is brought against them. As a living man and as a jura summa imperii, he eschews using an attorney and has thus prepared the following objection, which he has filed into the County Circuit Court. And it reads as follows. The Circuit Court of the State of Oregon for the County of Washington Probate Department, case number 26 PB02355. This is an objection piece. I am here so as to not acquiesce to 2P26 PBO2355. Be it known, it is content over form. Notice is the agent. Notice is to the principal. Notice to the principal is notice to the agent. I am the surviving spouse that was denied to the will that is not a will. It is a bogus trust that fails due to fraud by the deceased, Aida C. Roman. I am the successor. I have paid my $281. I claim this case stop and provide subject matter jurisdiction as required. I claim this is caveat to will and probate in open court. I claim to be sui juris and in propria persona jura summa imperii. I will also need territorial jurisdiction in Article 7 amended authentication, also venue status and law form. All of the current Washington County judges listed on the website will need their copy of their oaths and bondability. The certified copies I got from the state archives are aged. I will also need certification and credentials, bona fides, on several points, specifically Article 3, 1 Supreme Court claiming original jurisdiction, Article 7, Amendment 7, Civilian Common Law and Equity Court of Record with ex parte Milligan implemented. Then venue status and law form must be questioned. The jury pool is U.S. citizens, which is illegal or illegitimate. This probate includes the quiet title, foreclosure, and subsequent claims such as, but not limited to fraud, mortgage fraud, fraud upon the people and others. Signed, sealed, and stamped, witnessed with proof of service to be published at www.orsja.org and other. And he has signed it, and 3 others of us have signed it as well, and this was submitted to the record for the case. The successor spouse filed a quiet title, that would be Ron Vroman, on his property to reclaim and to clarify any confusion regarding ownership of a living man, having lived in their shared property for the same 20 plus years. Here's the quiet title filed and recorded on 01/07/2026. Countless entities are involved in a whole heap of paperwork, from the title company, the VA loan administration, and digitized mortgage electronic registration system, which the acronym for is MERS. It transposes an analog contract into a digital facsimile, and we are not deceived. The Washington County Recorder, this is more paperwork, from Washington County Tax Assessor, Washington County Sheriff, Washington County Probate Court, attorneys for their entities, and petitioner and her attorney. The mailbox has been full, coming and going. In summary, our constitutional Jural Court of Law and Equity has been involved in all of this since the August 2025 death. Our court of record, being one of original jurisdiction and following the laws of nature and of nature's God, considers all the permutations and evidence, not from the perspective of monetary gain on anyone's behalf, but from the right and true perspective of the integrity and dignity of a living soul's unalienable rights, to include the basics of shelter and survival, and of his or her life-earned material properties that provide for these basic needs and for one's comfort for their remaining days. Thank you.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. And then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, shot him 3 more times.